a bit to cover today, and I'm going to hand it over to Thomas Eberly, who is going to lead us through some discussions based on their findings from their report. Tom, is there any other introduction or anything else you'd like me to cover before passing the reins over?
No, that's perfect. Thank you.
Thank you.
Good afternoon, everyone. I gotta say this is a very impressive group of people participating in this meeting, and I'm very grateful for your time this afternoon. I know you're very busy, and I hope that we can generate some good ideas that we can put into a grant that we want to submit to the MacArthur Foundation. Just a little bit about myself. I'm the program director for the Justice Management Institute. We're based out of Arlington, Virginia. And prior to joining JMI 5 years ago, I was a criminal justice director for Mecklenburg County, which is Charlotte, North Carolina. Currently, I'm also working with sites for the Safety and Justice Challenge in Las Vegas, Houston, and New Orleans. So I'm going to jump in if you don't mind. The reason we're getting together is because Missoula County is going to submit a renewal application to the MacArthur Foundation. And the MacArthur Foundation created the Safety and Justice Challenge to help reduce mass incarceration in jails across the country, and also to reduce racial and ethnic inequities in the criminal justice system. Missoula County was one of probably about 36 jurisdictions across the country that was selected, hand-selected, to participate in the Safety and Justice Challenge. And you were picked based on the application that you submitted a couple of years ago, which included different ideas that the foundation found really appealing. One being case processing, improving your case processing, creating the Calibrate program, putting social workers in the public defender's office, and implementing the PSA are the things that come off the top of my head. Those things are, some of them are already in the works. Some are up and running. And right now, as we go toward the second go round, so to speak, with the foundation and submitting a grant application, it's just a really healthy thing to do, to step back and say, okay, what do we need to do better? What do we want to tweak? What new ideas can we bring to the table that will make the application appealing? And so that's really why we called you all together, is to really just have a brainstorming session to get your input, your buy-in, and hopefully your support over the next couple of years for some of the ideas that we generate. As far as how your site's doing, prior to COVID, you were above the goal that was set for you by the foundation. The foundation wants to see you at 149 inmates based on analysis they do, comparative analysis they do of other jurisdictions, your same size. And they feel 149 inmates is appropriate for your population size. You were about 165 to 170 before COVID. And after COVID, you're actually below your target goal, which is good, but that's not the way we obviously wanted that to happen. So as we go forward and we submit this new application, what we're looking for, like I said, is some new ideas. And that's part of the reason we got together with the county staff, and we gathered some data and we did an analysis. And when we put together these two analyses, one was a snapshot, which looks at who's sitting in your jail at a given moment. And then the tracking analysis looks at individuals who were released from your jail during a certain window, usually 2 weeks. And when we did those exercises, it was kind of interesting because we saw something that kind of stuck out. And that was, you had a significant number of failure to appear sitting in your jail. You also had probation and parole violators sitting in your jail, revocations of suspended sentences, and also throwing into the mix pretrial release violations. And when you add up those four categories, prior to COVID, they comprise 43% of your jail population, which is, I'll just say, it's a little bit unusual. After COVID, likely due to some changes that you made, the percentage dropped down to 31%. So it's also interesting when you think about failures to appear, probation and parole violations, revocations for suspended sentence, and pretrial release violations. I mean, they almost have kind of like a same feel to them, in the sense that they're people not doing what the court instructed them to do. And so, what can we do as a system to kind of fix that? And that's the kind of conversation we want to have today. And so that's the goal for this meeting right now. So if you don't mind, I'm just going to jump right in and turn this into a brainstorming session. And starting off with failure to appears, I got to imagine that failure to appears are very frustrating for the courts. They're frustrating for the court attorneys. It just slows down everything. It delays case processing, creates a backlog for everyone. And then when they get rearrested and get stuck in your jail, it's just consuming resources. Well, acknowledging that failure to appears is just one of those things that annoys people, frustrates people. Really like to have a conversation about, from your experiences from the bench or from working with your clients or prosecuting, what do you see as the causes for failure to appear? And then the follow-up question is going to be, okay, what can we possibly do to reduce those failure to appears? So I'm going to throw it out there, from your perspective, what's driving the failure to appears?
Thomas, if not to interject myself, everyone, because I'm kind of just this guy who's coming in from, the homeless outreach team. This topic has a lot of personal responsibility for me, and I believe in honest, sincere, and forthright expression. Sorry if I'm slipping up on my words. I'm very excited now. So I myself have spent a significant portion of my life within the criminal justice system. And speaking in all candor, I am currently on paper. So I understand every aspect of what it's like to, I guess, coming from the demographic of the person who's experiencing the flip side, not the administrative side of, the systemic issue, which is our jails are overpopulated. I know Billings' jail is at 3 times its capacity, which is where I'm from. So I know for those people that I'm currently serving that the reason they miss failure to appears is a lack of contact with resources. And it mostly stems from a misunderstanding that's resulting from the stigma with the homeless. And I also know, coming from the point of view of people who are on paper, people who are in pre-release, people who don't understand that the systems and things that are in place are here to help them be successful. It comes from a lack of education. And then you get this fear. And so I know a lot of my friends, and even myself in my past, when I, had a parole violation and then I got scared, and then I developed this attitude of like, oh no, I'm screwed. Oh no, they're going to lock me up. Oh no, what's going to happen? And I've realized as I've gotten older and I've become more of a responsible adult and community member, communication is key. And if there is education about why things are the way they are, I think it would help people better understand and become more trusting of the system, which would also then in turn cause a mutual trust and communication between, say, a parole officer and, a parolee or a social worker and their client to better aid and make sure that they meet these meetings. And I think overall, in the bigger picture, if we can proactively kind of get to the quick and cut the root issue, that'll take down their jail size and population. I know you just wanted to talk about failure to appears. I just kind of wanted to put out where I'm coming from on all this, because like I said, I do have to get to another meeting. So I don't know, guys, if that answers your question, and I'm sorry if I'm just like overflowing and blurting stuff out. I'm very excited because I've been waiting to have a meeting like this since I started getting into the criminal justice system, because quite frankly, I think we're always striving to do better, and we're always striving to do our best. And I think, like I said, communication is key. And if there are programs that are in place that better educate not only the people that are being served by these systems, but also these service providers to create that trust and communication, I think it would make all the difference in the world, quite frankly.
Okay, I appreciate that, Riley. I think you brought up a good point.
I am Lori, and I want to go right after what Riley just said. Being a person with lived experience, being a person who's been through the criminal justice system, being a person who's lost my license and been in jail, most of my time spent in jail is because of failure to appears, non-payment of fines, things like that. Now, with me, like what Riley says, it has to do a lot with fear, and the situational lack of services, addiction, getting clean and making appointments is one of the hardest things I ever had to do. And when I was going through it, there was no support. So like what Riley said, it's education and being a person, a returning citizen, a community member, a peer. I think that those failure to appears, they aren't, in my opinion, like, oh, I just don't want to show up. Like, it's rarely, I just don't want to show up. It's with all the peers that I've worked with and myself, it's always fear. I don't have the money. I don't want to go to jail. I don't want to be accountable. All of those things, they all come into effect.
Great. Thank you, Lori, for sharing that. Can we hear from maybe a couple of judges, what you're experiencing from the bench, please?
I'll bite. This is Judge Dayshop. I just was really fascinated by the last two speakers because they both kind of identified lack of communication as an obstacle, and of course fear. And I understand the fear piece. I don't exactly understand the lack of communication, because there's lots of communication about their next court appearance and when they're supposed to appear and things of that sort. And it seems to fall on deaf ears. And it kind of ties into the fear thing, because if they show up and they do what they're supposed to do, then they got nothing to fear. It's when they don't do it that the problems snowball on them and get out of control. I understand if you owe a bunch of money and you don't have the ability to pay, but even then, I think virtually all of us would say if you don't have the money, you're making a sincere effort, you got some kind of a plan, we're not going to throw you in jail, we're not going to punish you, we're going to work with you to try to get you so you can deal with these financial obligations. But I don't know. I've been a long advocate of, and I keep hearing that we're going to do this, and maybe we do have it in place. But one of these programs where you get a text message a day or two before the court appearance, maybe the night before, reminders that you've got this court appearance, I think that would help and would go towards a communication thing. But beyond that, I don't really know how to communicate with these people. All they need to do is show up and do what they're supposed to do, and we won't have a problem.
Tom, we've got Judge Jenks and Julie Merritt and Terry Kendrick with their hands up as well. Judge Jenks, I think you were trying to speak before and your mute button was on.
Probably. I guess I just wanted to comment that it's interesting that the failure to appears are up since COVID. And the reason that interests me is that the county has essentially banned municipal court's failure to appears from the jail. So if the failures to appear overall are up, that would suggest that they're the felony failures to appear that are up, which is kind of a serious problem. And then I wanted to also, from our perspective, post-COVID, our court is pretty much gutted. I mean, we can't do anything about failures to appear at this point, and everybody knows that they don't have to appear. So, I mean, I'll see somebody on 10 or 15 warrants for failure to appear, and I have to release them. I tell them to come back in 2 hours when their attorney's there. 2 hours later, we just reissue the warrants because they have no intention of coming back and won't come back. There's no upside to coming to court. And then I wanted to kind of follow up on the lack of communication and sort of what Judge Deshaw says. You know, the court communicates pretty clearly. But where I see, or what it appears to me from sitting on the bench, where I see the huge lack of communication ends up being between the public defenders and their clients. And there's no follow-up. Most of the time we come into an omnibus hearing, which unfortunately is 2 months after the initial, and there's been no communication at all. So the defendants who do show up don't know what they're there for. The attorneys are then making decisions on the case, having not talked to the client prior to. And so that's, I think, a huge problem. And I think that definitely contributes to failures to appear, but also to non-compliance. I think there's got to be a way to improve the policies at the OPD or the practices at OPD or something to improve communication so that defendants have someone that they can talk to. So that is something that concerns me. And I think that's all I've got from municipal court.
Thanks, Judge. I'm kind of surprised I'm not hearing anyone talk about, you know, like people complaining about not having childcare or transportation or something along those lines. Obviously, fear is a very powerful reason for people not to show up for court, but are there more practical reasons that you've encountered?
We do have quite a few people with their hands up. Tom, maybe we'll go to Julie Merritt. I think she was next in line, if that's all right. And if you've had a chance to speak, turn your hand off, and then I won't call on you again.
Thanks, Kristin. Julie Merritt, Harris City Council, and I'm afraid I don't have an answer to what Tom just asked, but I have a couple of thoughts in my head as I totally understand the fear and the anxiety as someone who's always suffered from anxiety. It's my reaction when there's something that I'm particularly anxious about is to just avoid it and pretend it's not there. So I can totally understand how that can be a big factor for folks. But I'm wondering what means are we using to communicate with people? Is the court typically just relying on snail mail? And if that's the case, I think that's something that we could maybe address as Judge Deshaw just alluded to, the concept of being able to send people text messages or emails, because I mean, I know that I personally can go for days without checking my mailbox. And then when I do, my response to something there may not be very timely. And then I am kind of curious about the extent to which the people who have warrants out there for failure to appear have actually been assigned a public defender or are otherwise represented. And I guess I ask that to maybe try and narrow down the place from which better communication can happen. I mean, if these folks are represented, does this situation speak to a need for more staff at the public defender's office who that's just their whole job, is trying to communicate with people and give people, once people have information that, yeah, they're not just going to get thrown in jail if they show up for court, that there's other options available to them, that maybe that might reduce their anxiety and reduce their resistance to being, going ahead and participating in the system the way that they are, that they need to get the situation taken care of. So sorry, that was kind of a lot.
That was great. Thank you.
I think next with their hand up is Judge Halligan.
Good afternoon. Thank you all for joining. So I just wanted to give a perspective that I do agree that it would be very helpful to let people kind of know ahead of time. And so I've thought about, doing business cards, trying to do the text messages. Of course, not everyone has a phone that can receive a text message, nor does everybody have, a computer that they can get emails. So for a vast majority of people, I think that would be helpful, and that's certainly one tool we could use. What I'm seeing a fair amount is people who, when they do come to court and they do know that they're going to appear or should appear, they either forget or they more or less purposely avoid us. So generally, it's my practice to call people. So if they're not in court, whether it's an attorney or anybody really, if we have a hearing and they're not there, I do try to reach out to them. Sometimes we are unsuccessful because the individual as well doesn't have a phone number. And so I do think we're kind of trying our best to make sure people are engaged. But I certainly have folks who will appear, as Judge Jenks said, and I'll ask them, even to appear just later, and then they purposely really don't appear. So those are the more chronic folks. And so even though our failures to appear are high, I would say that we as judges do try to give people the benefit of the doubt. We try to reach out to them. And we're really not trying to issue warrants unless it's pretty clear to us that they've lost contact with an attorney, they've lost contact with anybody else in the justice system, and they're really kind of just avoiding us. And it isn't our, desire to keep having to issue warrants, but for some folks, it seems to be a pretty chronic condition. And whether or not that's because of their fear or because, they're engaged in other violations of kind of the conditions of release and don't want to be caught or placed in custody, it's really hard to speculate about why they might not be there. That's really all I have to add.
Thank you, Judge. The next person with their hand up is Judge Veneta.
Good afternoon. I would like to echo the remarks of Judge Halligan and Judge Dayshaw. In response to some of the questions I heard asked, yes, at least in district court, most of the individuals who have failed to appear do have attorneys appointed for them or private counsel. It's been my experience that at least in Department 5, and I think this is across the board for all 5 district court judges, we're very slow at issuing warrants on a failure to appear if they have been maintaining contact with their attorney. I've usually taken that at face value and set it for another time to give them an opportunity, the attorney an opportunity to get them in. If there's any indication that they are still engaging with the system, typically, again, give them another opportunity to get in. It is when we're issuing warrants, it's not on the first failure to appear. It's not on the second failure to appear. It's often on the third or fourth failure to appear. And that is really when they've completely disengaged. They're not in contact with their attorney. They haven't been checking in with pretrial supervision, if that's the case. So when we also base our metrics on the issuance of warrants, we need to recognize that there's been a host of failure to appears leading up to that warrant. It hasn't just been on the first time. I know Tom had asked about other reasons for not making court. I think one of the reasons why there isn't a question about transportation is because, of course, the county courthouse is right outside the bus terminal, main bus terminal, and to travel on that bus system is free. So there really is not a good reason, unless they're outside of the service area for Mountain Lion, as to why they are not attending. I know that I have had individuals, mothers and fathers, bring their children to court. I know it's not comfortable for them, but I'm certainly not going to, I would much rather have them appear with their child in tow than not appear at all. I would also agree with Judges Halligan and Dayshaw that whatever additional tools we can engage to help people stay in contact. I know that many of the failure to appears are individuals who are homeless, are individuals who do not have access to technology. I know with our ability to now zoom in for virtual court, people can call in and that's sufficient. People can video in, that's sufficient. Oftentimes they don't have sufficient minutes on their phone. I've tried to address that, and I think other judges have addressed that by making the phone call just as long as they're standing by. We will call them so that they don't have to unnecessarily expend minutes or data on their plan waiting for the court to call their case. But always looking forward to additional ideas for reducing the failure to appear rate and increasing the engagement of defendants with the system. Thank you.
Thanks, Judge.
Thank you, Judge. We do still have quite a few people with their hands up. I'm just going to keep going down the line. Ann Miller, please.
Well, I think I've spent my recent career focusing on trying to figure out ways to engage people so that these problems don't occur. But I can tell you that just as really probably repeating what some people have already said, but the issues that bring people into the criminal justice system contribute to them cycling, as does the collateral consequences. So that contributes to failing to appear. So mental illness and addiction contributes to that. Loss of jobs and income, lack of childcare, lack of transportation, those kinds of collateral consequences contribute to failing to appear. And regarding the comments of the first two speakers, that concept has been studied, and it's called procedural justice. And people who believe that they are being treated fairly in the justice system, win or lose, are going to be more successful. There's been studies that show that. So that contributes. Communication is a huge problem, and it's a problem for people that don't have addresses, that are homeless, that don't have phones. We're dealing with that now, especially with COVID, and we're trying to facilitate remote appearances. So one of the things we've done is applied for funding to purchase phones and minutes for our clients so that we can have contact with them. There's an organization called UpTrust whose purpose is to reduce mass incarceration. And one of the things they offer is technology for the text messaging that Judge Desha referred to. We have a pro bono agreement with them that they're going to offer that technology to us. We just can't get the software company not to charge us to integrate the program, but we're still working on that. So not only is it text messages to remind people of coming to court, but it's also you have an appointment with your mental health provider, your medical provider, things like that. So of course, people need phones to do that, which is why we're trying to get funding for that. So the failure to appear, I think, really is a symptom of all of those things that contribute to people cycling. And it isn't simply people just saying, I don't care. I mean, maybe that happens sometimes, but that's not, it just isn't the answer. So those are my observations so far.
Thank you.
Thank you. And I just wanted to say really quickly, we are talking about phones quite a bit. We are just rolling out a phone program through Justice and District Court and OPD. It's just getting started. If anybody has any questions, if they need phones, if they need minutes, if they need plans, please call me and let me know, and I'll help get you set up for that for any defendant that has a need in an active criminal case. Next on our list is Danny Tenenbaum, please.
Hi, I just want to echo what Ann said about the efficacy of text messaging in reducing failure to appears. I think there's quite a wide body of literature that supports it being a very low cost mechanism to get people to show up to court when they need to show up to court. But then I would also add that it's worth looking critically at what are these court dates that we're obligating people to to attend? And is it really necessary for defendants to be appearing at these court dates? I know as a public defender, I work on appeals, so I don't really have court dates, but a lot of these court dates are status hearings or omnibus hearings where you have someone who will take off work or have to arrange childcare or care for an elderly family member to appear in court for a matter of minutes, where they stand next to their public defender and get a new date to appear perhaps 2 months in the future. And there really was no need for them to be there. And I think it's worth looking critically at whether we need people to show up at these court dates. And I think that's a really effective way to reduce failure to appears, is to really make sure that the only dates that we require people to show up at court are the dates where it's necessary for them to be there. That's just a thought I have.
And I just want to jump in on that one, because that's a fantastic idea. And we're seeing that more in other jurisdictions, where the only hearings that the defendant's attending are the ones that are required by statute. And that's made a big difference.
You're muted, Kristin.
Thank you. I just wanted to mention too that we're hearing that other jurisdictions are allowing folks, defendants, to go in and use a Doodle Poll, basically, to apply for a court date and time that works for them, that also works for the defendant, or for the judge and for the prosecutor and for the lawyers, basically. And that's something that would be really interesting to look at, because it's working really well in other jurisdictions. And then folks have the ability to make that appointment that they know they'll be able to attend. Thank you, Danny. Next up with their hand raised is Jennifer Striano.
Hi, thank you. I just kind of wanted to address a few things. Obviously, I definitely agree with Danny in terms of the amount of court dates that clients are required to be at can be overwhelming for them as well. And that kind of also decreases the level of importance of it when they go and they feel like nothing happens anyway. They don't realize not going is such a big deal. But I would also just say, as far as the public defender's office, we are, a lot of I would be interested to know, first of all, I guess I was under the understanding that the failures to appear, the numbers have gone down after COVID. Okay, so not up. And so that makes a little more sense to me. But so I would think that a lot of it might be from their initial appearance to maybe their second appearance, because sometimes like in municipal court, if they appear like in September, their next court date is not for 2 months out. They walk out of that courtroom, they kind of throw that piece of paper away, and they don't really think about it. And so unless they have a valid phone number, unless they have a valid address, there's really no way that we can get a hold of them anyway. I mean, and so that's the challenge. We're not trying to get a hold of them. If we can't get a hold of them, it's due to the fact that we just have no ability or any way to do it. Our office sends out automatic reminders for every court appearance to any phone number that we have. Our office sends out mail address, to any letters that we have, to any address that we have on file. We have staff that goes on Facebook looking for clients constantly. I communicate with a lot of clients on Facebook. So I think our effort is there. We obviously can always improve, but I think that we need to look to what are the barriers that the clients are having that we can't get a hold of them. I don't think it's really a lack of effort on our part.
Do you think that coordinating with the outreach team to have a list of people that are not, that you can't contact? Yes. Because I know a lot of them are like, I am under the impression that the population that is highest on the failure to appear are homeless, people who are struggling with addiction. I mean, it's a pretty targeted population. Totally. I think that outreach, we do have those connections. We do have those special relationships. Mm-hmm. And they trust us. Mm-hmm. So I wonder if we could coordinate and get like, hey, don't forget. Yeah. It's just a simple, don't forget. here's a phone. You have no excuse now. You've got this connection.
Right. So one thing I will say, we have been in contact with the POV a lot more recently, and even pre-COVID, we had some ideas about kind of getting a shuttle from the station to our office. But we have kind of, I know our investigator has gone out with the hot team before, and I know our case managers have gone out with the hot team, or we'll say, hey, we're looking for so-and-so. If you see him at one of the camps, let him know he has court. So we're trying to coordinate with them a little bit more. We've given all of the court calendars to the POV so that they can look up. So they'll go there and say, oh yeah, you do have court today. So we send them every week updates of the court calendars to try to help with that. We are in communication with them also to try and see if we can set up a room and a computer where they can appear by court by Zoom at the POV. So that would also decrease a barrier in terms of transition and things like that. So so we're really trying to connect those dots a lot, because we do see a lot of overlap with those clients.
So I got a quick question for Jennifer and Matt. I mean, do you see a judge or a courtroom that does maybe a little bit something different that seems to work a little bit better when it comes to FTAs?
I don't know that there's a silver bullet, Tom. I did want to reflect on one of the big changes that was made in filing felony cases up from justice court to district court that started at the beginning of this year, that I think has helped a little bit, but it's also had some shortcomings. And I think it might be a really interesting area for this group to sort of analyze, look at some data, and maybe even do a poll of some of the people that aren't showing up for arraignments. And so just as a little bit of context, if I can, it used to be that somebody would be in custody, they would appear in justice court, and they wouldn't know when their arraignment date was, because they wouldn't necessarily know when it was getting filed up into district court. And that caused a lot of confusion. And Jennifer and her team were really instrumental in kind of pointing out how difficult that was. We would have people fail to appear at their arraignments, and their public defenders would say, Your Honor, they have no knowledge of this going on, and they don't have an address and they don't have a phone number. And they identified that problem, and so our district court judges, and particularly Judge Marks, really helped try and come up with a solution. And so now when somebody appears in justice court, they're given a date certain for when their arraignment will occur. And they're given a piece of paper, and they're verbally told in court, and they're appointed a public defender. The reason I'm raising that issue, though, is I'm not sure statistically whether that's really helped improve failure to appears at the arraignment. There's still a lot of people that end up not showing up. And it's a head scratcher for us, because we know at that time they know exactly when it is, and they're told, and it's not very far out. It's usually, the next week or a week and a half. And there's still a lot of failure to appears. There was a comment a minute ago about FTAs decreasing during the time of COVID, but it is my understanding that the data being tracked is still only warrants being issued for failure to appears. And I have pointed out repeatedly that our district court judges in particular are not issuing a warrant on somebody's first failure to appear. So typically by the time a warrant has been issued, they've been given many, many opportunities, usually over a few different weeks. And I know if communication is not there, then a few weeks might not make a difference. If you don't have a way to contact somebody, 3 extra weeks might not really matter. But it makes me wonder about those methods of contact that might really work, and what we can do to improve that. There was a comment on statuses a minute ago too, and I want to be clear that maybe in the past there were some statuses that were pretty unnecessary, and I guarantee you the state doesn't want to have to put in notes and appear for a status every week either if nothing's going on in the case. And so that's not necessarily something we're pushing, and I'm not seeing a lot of that from the district court judges either. Often a status is something like somebody is being released from jail to go to inpatient treatment or to do some other sort of thing that's part of a release plan, and we want an update on whether that occurred. But if somebody ends up having a status 2 weeks later and they don't appear, and their public defender says they're at treatment at Rimrock and they don't show up, nothing's happening. I mean, at all. We're just trying to check in and make sure that somebody's on track. And in many cases, having those sort of contacts, I think from the state's perspective, probably helps the defendant have a better outcome, because if we know over a period of time pre-trial they're out in the community and they're doing well and they're complying with conditions of release and they're getting help, we often end up looking more sympathetic towards somebody as well. So I think that's a great thing to look at, the number of statuses and maybe whether one department over another is doing something different, and maybe Jen or her team might have some perspectives on that. But from the state's perspective, they can actually be helpful, and I would say that in many of those cases they might end up being beneficial to the defendant. It's unlikely that somebody is getting a warrant out for failing to appear at a status if nothing substantive is occurring. That's just not something that is routinely happening, at least on the first failure to appear. Now, if there's 5 or 6 statuses in a row and nobody's seen somebody in 4 months, that's a different story.
So can I ask, is there a different alternative than putting someone in jail for a failure to appear in Missoula County? Is there an increased level of supervision through pretrial services? Is there electronic monitoring of some sort?
Well, I mean, the answer to that, Tom, is yes, but the only time they're ending up back in jail is because we don't know where they are, and so warrants getting issued. Very often, if they show back up and they have a good excuse, or they didn't actually get in any other trouble, but just nobody's seen them for a while, they get admonished by the judge and they're told that it's very difficult to do things in the court, and they're expected to appear, and how can we make this better? And they're very often given a lot of chances. I mean, there aren't many situations right now, especially with the 5 judges that we have, where like a nonviolent offender is sitting out their time in jail for their first, failure to appear. It's usually a culmination of multiple charges over a period of time that's doing that. Now, there are property offenders that end up in jail. The state doesn't want them in jail. We have to pay as a county basically about $110 per day for somebody to be there. That's not our objective, but sometimes we run out of tools. Pretrial has strained resources as well, and it's not always sufficient. Very often those failure to appears are also accompanied by absconding from pretrial and a pretrial officer not hearing from somebody for an extended period of time.
When does treatment court get to be an option? When does that get brought up in the conversation? Because treatment court is a good alternative.
Sure, it's always an option, and a lot of pretrial defendants do engage in treatment court, and that often ends up being very beneficial to everybody involved. I would hope that it benefits the defendants as well, providing some structure and getting them help. But that doesn't always happen. It's often only after sentencing. It depends on the circumstances and also the defendant and whether they're accepted or not.
Do you think that giving them that option early on, that might be a solution, would lessen their fear, or give
I know
them
Judge
kind of a
Halligan's.
hope?
Well, maybe Judge Halligan could opine on that too, because I think they're really trying to have early engagement with drug offenders for the SMART court. And I know all the treatment courts are preferring to engage people earlier, closer to the time of the offense. But like I said, it really depends on the circumstances and what somebody's trying to do.
Thank you.
So Judge Holloway's had her hand up for a very long time.
All right. Well, good afternoon, folks. I just feel like we should probably hear a little bit from Justice Court and what the things we have been doing. But first, I want to just back up. When I take a look at the Missoula County jail analysis and we're looking at the failed to appears there, the numbers aren't too alarming. And so I'm wondering if we can, at a further date, have that more dialed in on where are those failure to appears happening and what's led up to that failure to appear. Because I don't know if we're talking about failing to appear on a traffic warrant or a district court warrant, and are those failure to appears also as a result of a pretrial violation, because you can have a double kind of a whammy there. So some things that we have done in Justice Court is that, first of all, a huge shout out to Judge Marks. When he took the bench, we started working together to establish those arraignment dates. It didn't make sense for somebody to show up in Justice Court on a new felony arraignment, and then there would not be a date that was determinate of when they would go up to district court on their arraignment. So for us, when somebody fails to appear, we send an order to show cause. We're hoping that we have the correct address. You know, I think that sometimes we have to remember that when we see those jail appearances, there is a certain percentage of people that may not be wanting to give us direct contact information, and therefore some of the court's efforts to follow up with people becomes, you know, fruitless. We are allowing people nowadays to call in via Zoom. Since COVID has happened, they appear via Zoom, and we're quashing warrants that way. We give them a court date, because the reality is we want people to be engaged in their court process. What, you know, and what is an acceptable number of failure to appears? I mean, what jurisdictionally comparison to other areas is realistic? We're never going to rule them out. It's kind of like saying we're going to wipe out homelessness. I know it's always a good effort. We want people to show up, but you know, I don't know if you have that information, Tom, like what's acceptable? What's a percentage?
It really does vary from jurisdiction to jurisdiction. It's usually in the 5 to 10 range. It depends on the, like I said, the jurisdiction.
All right.
And well, the resources that are available.
That's good to know. And to know a little bit more. We do a couple other things in justice court. When they don't show up, we send an order to show cause. And before we actually issue a bench warrant, because we really do need to have some type of placeholder in the case, we have clerks call. They reach out. We also, through Judge Halligan's request several months ago, we've started to collect email addresses. And I know the public defender's office has been using those email addresses, and the county attorneys when it's pro se individuals. So the more contact information we can gather is really helpful. I know that there was a resource postcard that went out for reentry folks or people who were incarcerated during COVID, and our motto has been call the court. Just call us. We want you to be engaged so that you can appear remotely. You don't have to leave work. And I know that there was a comment made about, do defendants have to show up for all their hearings? If they're represented by an OPD, we have said, unless it's a time for sentencing, or we have directed them to actually appear or call in, that public defender can appear on their behalf. So I think that I should be, and you know, I know several people on this call know that, but I think it's worth to know that I think the courts here, we all really do make an effort to find people, and and where do we connect that gap, or where do we fix that gap of how do we find people before they're arrested and end up in jail to get them engaged? So thank you.
Point. That's an excellent point. And I'm looking at the clock and I'm getting a little anxious because I noticed we promised an hour. We're just talking about FTAs. But I do feel like we've really identified a few areas that are worth exploring a little bit more. Going back to the very start of the conversation, you know, maybe there's like a lack of resources that will be appealing to individuals who are timid about coming to court, or don't understand the court process, or have behavioral health issues that, you know, make it more difficult for them to comply with the requests of the court. And so I think, you know, that's one thing that really stands out. You know, addressing the fears, and, you know, a lot of concern about, you know, people are concerned, you know, will I go home if I show up for court? Or am I going to put in jail or something like that? And again, that ties into someone mentioned procedural justice and improving communication, and it's, you know, making sure that people understand the expectations of different court events and what is likely to happen during those events. And so I think there are some soft touch things that don't require a lot of investment, that could pull in some community resources that seem eager to participate, that might be beneficial and might be a good fit for the grant, and, you know, ultimately help improve the functioning of the courts, because you don't have all these FTAs. I gotta say, I'm really impressed with all the steps that you are currently taking to minimize bringing people in on FTAs. You know, waiting, making calls from the courtroom. You know, the stuff that the judges have shared with us is I bet the community doesn't even know that they go to those lengths. And so that's that's really impressive.
Excuse me, Tom.
Yeah.
We do have Judge Deshaw's hands up, and since he's a district court judge, I wonder if we might just give him a chance to have another comment. Is that all right?
Yeah, absolutely.
Thank you. Judge Deshaw.
There I go. The only thing I wanted to talk about was earlier on when Jennifer was discussing things. Somebody said, well, a lot of these court appearances are long and tedious, and people show up and nothing happens, and there isn't any real need for them to be there because nothing happens. Well, I think I can speak for every district judge. I would wager that 70 to 80% of the cases that are on my criminal docket every week get continued for some reason. And this isn't something that just happened recently. It's been that way for 50 years. And I always thought, why don't they just go out in the hall, or why don't we go out in the hall when I was an attorney and spend 2 or 3 minutes and we'll talk about this, we'll get things settled, and then we don't need to pick it down the road for 2 weeks. But a lot of these court appearances, people show up for a non-event. And if attorneys would take the effort to try to resolve these things in a timely fashion, I think it'd speed up the system. It would reduce vastly the number of court appearances that these defendants have to make. And I think would go a long ways toward making the system work better. That was my primary comment. And thank you.
Well, that's another excellent point. So much of the work that happens on processing cases takes place right outside the courtroom. And so it is like a catch-22. You don't want to make people show up, especially if nothing's happening. They feel like I just wasted my time and had to call off work. But then again, the flip side of that is what the judge just mentioned. So I feel like we have a few different ideas. One is maybe something along the lines of some kind of peer court navigator to work with people, maybe at certain hearings in particular, the arraignments, who can explain to them, what's happening, what's the next court date it's going to look like, and when it's going to take place. That's one idea. Another idea is to jump on the suggestion about improving text messaging or emails to defendants to make sure that they're fully aware of their next court date, and maybe include directions to the courthouse in that text message or something like that. And then we also talked about maybe exploring a little bit more deeply about the impact of homelessness on the failure to appears, and having a conversation with some of our community folks to see if they have any suggestions and maybe opportunities for them to step up and be of assistance. The other more interesting ideas was the increasing the use of Zoom for some hearings to make it easier for people to attend. And one of the things I've also kind of very interested to see how this works out, and that's the use of the Doodle Polls and letting people select dates that they're going to be available, and allowing them to say, I can make it on that day specifically. So with that summary, does anyone have any things that they're excited about or would not be excited about from that list?
I'm always excited about anything that has to do with peer support.
We need to keep you around.
We have a comment from Judge Deshaw and Julie Merritt again. So Judge Deshaw, please.
Okay, the Doodle Poll. I don't know how well it worked in district court.
Sure.
Typically, I let the defendant set the next date. But of course, they've got a public defender, so I'll say, all right, how about this range of dates? They pick the date, I don't. And we don't have enough flexibility in district court to let people use a Doodle Poll to do that. I just don't think that'd work very good, at least in district court. So an interesting idea, but I don't think it'd work for us.
Okay.
Julie Merritt, please.
Yeah, really quickly, I was just thinking as Tom was talking, if people show up for their initial appearance, it would make sense that we not let them leave until we have a reliable means of communicating with them, and maybe that's where Kristin's effort to come up with some cell phones to be able to provide to people comes, where one of the places where that enters into the process is if they don't at that point in time have a reliable way of communicating, then we can provide that to them, and maybe we can increase that communication by doing that.
Okay, well, this has been a really helpful conversation. I know we're past our time. I really wanted to delve into probation violations and revocations of suspended sentences. Unfortunately, I'm afraid I'm going to ask Kristin to maybe create other little focus groups so we can have similar dialogues, because I feel like each one's worthy of a conversation. In terms of next steps, I think what we'd like to do is jot down some of these ideas. We'll send them out to other participants and maybe ask them to rank them, or maybe add some things on that they felt like, oh, I thought of this after we dropped off the call, and really just try to bring together maybe a list of priorities that we can share with your community advisory group, or your CJCC, I should say, and say to them, these are ideas that were generated, and how do you feel about supporting these in our renewal application? It really doesn't take much. It's just a little twist over here, a little tweak over there, small pot of money, maybe a policy change, and you make a difference. It all adds up very quickly. But you're already doing a lot of good things, which is just really nice to hear as well.
All right, thank you. There's a few of us who need to jump on another call for jail review team. So anyone else who may have a comment that they would like to share after the meeting, please feel free to reach out to me. And we'll be in touch with next steps, and I'll see the jail review team on another Teams meeting call. Thank you.
Thanks so much, everyone.